Good evening, ladies and gentlemen. Will the County Services Committee meeting for Washington County please come to order? I have asked Justice Robert Dennis to lead us in the prayer and the pledge. If you will please stand. Robert, will you put on your, okay, thank you.
Our most gracious Heavenly Father, we come to you at this time. We just thank you and we praise you for all that you do for us. Pray that you would be with each here. Pray that you would continue to help us to be the best country, the best state, and the best county in the world. Pray that you would be with our county employees, keep them safe during the week, their work. Pray that you'd be with the citizens of our county. Just bless them and help them in their lives. Also, in America, be with our leaders as they make some very tough decisions, and be with us as we make some decisions, and pray that we'll have the discernment and the wisdom of doing the right thing. These things we ask and pray in Jesus' name. Amen.
Amen.
May we salute.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you, Justice Dennis. I have Justice Massengale.
Yeah, I make a motion we adopt the agenda. Second.
I have a motion by Justice Massengale to adopt the agenda and a second by Justice Lyons. All in favor? Aye. All opposed? The agenda has been adopted. Next on the agenda is the chairman's report. I'd like to say Washington County received $4,000 worth of overdose drug Narcan from the Arkansas Opioid Recovery Partnership on June 24th. Judge Deakins stated that it is another tool in the toolbox in supporting the community. Another tool in the toolbox is the Community Rebuilding Initiative, known as the CRI. These partnerships are helping us achieve our goals, which is to end drug abuse and get people the help and resources they need to be productive members of our society. With that, congratulations to all those involved in making this possible. Next on the agenda is item number 5, the Juvenile Detention Report by Director Tinsley. Good evening, Director Tinsley.
Good evening, Madam Chair. Excuse me. And good evening to the County Service Committee members as well. Here's the monthly report for June 2025. This report for June 2025 is covering 26 days of data. In the month of June, we had 22 intakes, with the average length of stay being 24.93 days. The average daily population was 8.71. The highest number of intakes were a minor in possession of a handgun felony at 6. Of the 22 intakes from Washington County and Madison County, 16 were from Division 3 and 6 were from Division 8. There were 6 total transports. All 6 transports were performed by the Juvenile Detention Center. Are there any questions that I may address at this time from the chair?
Justices, does anybody, I have Justice Rivera-Lopez.
Good evening, Director. I just had a question. So on the minor in possession of a handgun, was that one isolated incident where there were several?
Yes, sir. There were several this month. School is out. That doesn't make an excuse for that. But yes, sir, it's relatively high. So there were several incidents. I scratch my head sometimes, but yes, sir, those were 6 incidents.
Thank you.
Yes, sir.
You kind of wonder, how did they get possession of these handguns?
A lot of times they're stolen, Madam Chair. A lot of times, these kids sell them on social media to each other. It's kind of alarming, but it's a thing that's going on right now.
That's very disconcerting.
Yes, ma'am.
I thank you for your report. Oh, I'm sorry, Justice Lemming.
Thank you, Chair. That across the nation, they've been saying that drug cartels been using juveniles for the drug deal because they don't get near as much trouble. You think that might be some of that same situation?
Yes, sir. Justice Lemon, we see that a lot in this area. I couldn't tell you how many kids take the rap for some of these local street gangs that they are involved with, just because it's a lesser sentence for them as opposed to if an adult were to commit that crime. It's sad but true. Yes, sir. Absolutely.
That's what I've been reading and seeing on the news and stuff.
Yes,
that's
sir.
really been happening.
Yes, sir. Thank you.
You can elaborate.
Oh, I'm sorry. Okay. Yeah, so this is something that has been going on for quite some time in Northwest Arkansas, where, the high-ranking gang members will recruit these younger kids, and these younger kids will go out and do things. And, it's the punishment is not as severe, again, as if an adult were to commit those crimes. And so we see it a lot of times. And, a lot of kids have been charged and tried as adults in this area as well, but, they've been given opportunities to rehabilitate, and they don't take advantage of those. And so it's just one of those things that we've been dealing with for, past 10 years now.
In the topic of gangs being involved with young people, I know that Benton County recently adopted Youth Matters as something that they incorporate as a gang intervention to reach children, where they are, if they are involved and identified as gang members. Are you familiar with that framework? I think you've worked with the director of theirs in the past, but this was years and years ago.
I did know a young man that was. I don't want to say that it was Youth Matters, but we were working with a young man that was from South Central Los Angeles that was an ex-gang member. Yes, sir. So I'm very familiar with him and his work. We try to get our youth involved in a Hunger in Action, a boxing club out of Springdale. So, we give opportunities. So this summer, since school is out, we do a lot of outdoor adventuring club things. So, we had a tug of war party on Friday, and the guys did community service out throughout during the week. So we do different things and get them involved. And so sometimes we go out to the Buffalo River and go kayaking. So we just try to get them out of their normal element and let them see some different things.
Absolutely. Thank you, Director.
Yes, sir. Thank you.
Are there any other questions for Director Tinsley? Thank you, sir, and have a good evening.
Thank you, Madam Chair.
Next on the agenda is item number 6, the Sheriff's Office. Good to see you, Sheriff.
Thank you, Madam Chair. It's good to be here. You all have your report in front of you. I won't belabor it too long. I know you've got looks like a lengthy agenda, but our bookings are down a little bit for this month compared to a year ago. The big decrease that we see is in our pretrial numbers, and we'll give the credit to that to the 2 circuit judges that are hearing our criminal cases in the prosecutor's office. They've really been working hard to work through some of those pretrial numbers. So you can see we were at 527 this period last year, and now we're at 433. So they've worked hard to help get our numbers down, and we're very appreciative of that. Besides that, I'll be happy to answer any questions someone might have.
I have Justice Koger.
Thank you. Just my regular questions, Sheriff. Like, how many were sleeping on the floor last night?
Last night, that number is down considerably. It was 66 at midnight, so that's down.
That's pretty good.
We had 160 previously, so no females on the floor, 66 males.
Okay. And what about the ADC commitments that are actually, I see what you have on the report, but it's 133. but are they, so how many do we have that are waiting beds at the Department of Corrections?
Well, the new commitments to the Department of Corrections is 103 out of that 133 number. 103 have new commitments to ADC, ACC, which is the Community Corrections. We have 7 for that, and the remainder of those numbers are parole violators waiting for their turn to go down on a parole violation.
Okay, and online, there's 41,309, does that sound
That's
about right?
correct, yes,
Okay.
yes.
What about the number of COVID and the number in quarantine?
No COVID, no quarantine today. So, yeah, thankful for that.
Okay, every time I'm at the jail, I notice what used to be the office where people go in, it's all under construction now.
Right,
Is that still the remodeling, or is that part of the COVID mitigation?
That's the remodeling that we approved the money last year, had to roll it over into this year. So we've got started on that construction, and it's probably a 3-month project from when they started. They've been going about 3 weeks now, so.
Okay, thank you very much.
Are there any other questions regarding the sheriff's report? I have Justice Dennis.
Madam Chair.
Bring your mic down.
I should know this, and I apologize for not knowing it, but I know how it used to be, but not now. Do the chaplains perform wedding services down there?
Yes, from time to time, chaplains, or we've had justices of the peace come down and do ceremonies down there.
Yeah, that would be me sometimes, but.
Yeah.
I told someone that there was a chaplain there, and they didn't know it, and so they ended up, I think, getting the chaplain to perform their wedding.
Yeah,
But
yeah.
I just wanted to see if I was correct on that.
Yes.
So, all right, thank
It
you.
doesn't happen often, but from time to time, we have a wedding there.
Right, yeah. Thank you.
Are there any other questions regarding the sheriff's report? You might as well stay there because the next ordinance has to
next one
do,
is,
correct.
Yes.
Item number 7.1 is an ordinance establishing a policy for the early release of inmates based on meritorious, good time, and/or for labor provided to the public entities. Would you like to explain what this is, sir?
Yes, there's a state law that says that to be able to give good time, the county must have an ordinance authorizing it. So this just gets us in compliance with state law. Something I thought had been done some years back, and we were researching it recently and discovered that it maybe back to 2015. It never got done. Talked about, a lot of things happened, but it apparently never got passed. So Attorney Lester was kind enough to help us get this drafted and get it before you all. So it's just kind of a housekeeping thing to get us in compliance with state law and allow us to give good time should someone earn it. We don't have very many right now that qualify for that. Only 9, I think, currently that we have in custody that might benefit from this, but we just want to be ready and in compliance.
Certainly, I have Justice Lyons.
Thank you, Chair. I move that we send this on to the full quorum court to do pass recommendation.
I have a second. Is that what you were going to do, Justice? Is there any discussion? I have Justice Dennis, then followed by Justice Bruns, followed by Justice Dennis. Oh, to second? Justice Bruns.
Well, number one, let me say, I think it's an excellent program. It's going to be, it's going to be great. I would like to ask the possibility to the county attorney. I didn't see in here where it was really identified of who is eligible for this program. I know there's a lot more than just misdemeanors and felonies that are committed that are in the jail, and it doesn't really specify that those are the only ones. I would, if it's okay, I'd like to make an amendment to add that.
What's the amendment?
To add that we have this program for committed felons and committed misdemeanors are the only ones eligible. Because
You need to make a motion.
I did.
Okay, I have a motion to amend ordinance number 7.1 to include,
Okay, to include that the people eligible for this will be the committed felons and misdemeanors to the Washington County Jail.
I have a motion. Do I have a second? Well, there needs to be a second in order to have discussion. There's a motion made to amend, and then there needs to be a second to continue in discussion. So if there's not a second, then it dies for lack of a second. There's no second, so it dies for lack of a second. I have Coger, okay. Thank you. Justice Coger.
Thank you very much, Mr. Chair. Sheriff, under 2A, it says the chief executive or his designee. Are you the chief executive, or is that the county judge?
I think, well, I don't know, I guess I could defer to Mr. Lester, but I would assume the chief executive in this situation would be the sheriff, but I'm not 100% positive on that.
Okay.
But that would be my assumption.
Okay. Well, then I have a couple of more questions. One thing about the classifications, it says criminal history. What crimes in a criminal history will lead to someone being denied a minimum or medium classification? Those need to be spelled out. Do we have that?
Not in this ordinance, but we do have rules promulgated at the sheriff's office that say if you have an escape charge, if you have an assault on a police officer charge, those things preclude you from becoming minimum or medium in your classification for your housing in the jail, and these mimic those same classifications.
Would someone who had maybe several failure to appears in their past, would that stop someone from being?
That might not necessarily eliminate them. Typically, we're looking for violence or escape, those type of things.
Okay, so we do have a written policy then about about who would qualify for which classification.
Yes, it's in our jail procedures manual.
Okay. So you can get information from the ACIC about criminal history on defendant.
Correct.
So, but you can't share that information like with other people, correct?
Right, only people within the criminal justice system.
For criminal justice purposes.
Correct.
Do you see that being an issue with making this work, or maybe that's what you're doing now? I don't know.
Yeah, we do now check their criminal history as we go through the classification process to determine where they're housed.
Okay, that's all I have. Thank you very much.
I have Justice Lopez.
Thank you, Chair. Sheriff, my question is pertaining to what job responsibilities around the detention center might entail. I'm sure, what does that look like? What are the things that they could receive? What is the sort of labor that they could receive compensatory time off for?
Mostly simple manual labor, cleaning, sweeping the floors, mopping, painting, washing walls, car washing, just general labor, picking up trash around the facility or any kind of manual labor that we're able to get them out.
Thank you, Sheriff.
Yeah, most of them are excited to get out and do it because it's better than lying in a jail cell.
I have Justice Rio Stafford.
Thank you, Chair. Just a housekeeping question. Well, first of all, this sounds like a really good program, and thanks for bringing this forward. My question is, I was kind of unclear from the explanation, is that we've never done this before, or we've done it before in some cases, but realized we didn't have an ordinance in place?
There's two different kinds of good time.
Okay.
If you look over in section 5, it talks about misdemeanor inmates that are allowed to work for additional good time. We currently do that. So if somebody,
Okay.
we call them trustees. We probably should call them riskies, but we call them trustees. And so they work extra time if they get a 10-day sentence for a DWI-3 or DWI-2, and they want to work, then they can do that in 5 days by working each of those 10 or each of those 5 days. So we already do that.
We already
It's
do that.
It's the
Okay.
meritorious good time that they get good time for working, but it applies to the felons as well as the misdemeanors. So they get a little additional good time with this ordinance that we don't currently do.
Okay, all right. Thank you.
Are there any other questions? I have a motion and I have a second to pass this on to the full quorum court with the do pass recommendation. Do I have any public comment? Yes, please state your name and where you're from.
Thank you. Sarah Moore, Fayetteville. I appreciate the conversation around this, and I do believe there probably has been a format of this happening. I've had just a few clarifying questions that I hope potentially one of the JPs will ask or additional discussion. One of the things that those that are sentenced in the Department of Corrections have the ability to get meritorious good time from county jails. So I hope to make sure to get clarification that potentially the wording of this won't potentially exclude any of those that are state sentenced, and then also hope we can get some clarification about how many individuals are typically, since we're seeing a growing population of state sentenced staying 6 to 12 months easily in the county jail, how many of those are able to get meritorious good time, because many of those are parole eligible by the time they're getting to the Department of Corrections, which saves all the taxpayers money. The other thing that I wanted to check is that it's been common practice, given our overcrowding and sleeping on the floors, that those that are given misdemeanor commitments of a small amount of days are usually booked in and out of the facility. And so I'd like to understand what our practices will look like, because we continue to see that head count in the jail be an overcrowded situation. If our practice will be to continue that, or are they going to be under this meritorious good time and those folks will stay and that population may grow? And then additionally, I just wanted to reinforce if there is, some kind of stated criteria that could be shared so that it is known within the population that are in the jail in the event that they aren't selected. Is that something that they have the ability to opt in and to ask for consideration potentially? And if those are anything that can be discussed tonight, I'd be very appreciative. Thank you.
Thank you. Is there any other public comment? Seeing there's none, all in favor say aye. Aye. All opposed? The motion carries and it will be added to, when we do a consent agenda. Anyway, going on to the next item, number 8.1. This is an ordinance, an emergency ordinance establishing the county planning board in a manner consistent with state law. Back in April, March, the state legislature enacted Act number 519 and changed the guidelines in which we, as the county, selected or nominated and named people to our planning board. I have Justice Lyons.
Thank you, Chair. Needless to say, this is enacted by the Arkansas State. We have to be in compliance with it. We need to be in compliance, I believe, Counselor, it's by August 5th, based on state law. So I think it's something that has to happen. Of course, as is usual, when the legislature passes a law, they don't give you any direction on how you do it. So I think that from my understanding, we've looked at the best way to get to be compliant with the law and had some consultation with AAC to understand what they believe the best approach was. Of course, they had no direction from legislation as well. So this basically is taking the best step forward to go through a process to get us compliant with state law, which basically simply abolishes it, and then it gets reinstated, and then based on the criteria that's stated by the state law, the board members are, you go through the process of the board members being appointed and confirmed, et cetera. With that, I we move this on to the full quorum court to do pass recommendation.
I have a motion and a second, and I have County Attorney Lester.
So JP Lyons is correct. Act 519, it was a real simple change to the law. The gist of it is now each county of the 75 counties, if they have a planning board, is required that a majority of those members be from the unincorporated area of the county. And so in order for Washington County to be in compliance, the legislature didn't lay out a plan for how that happens. I reached out to legal counsel and kind of talked to them, and I felt like this was probably the easiest and best path forward, which would be to just basically end one planning board and then start a new one under these new rules, which adds that from now moving forward, a majority of those planning board members must be from the unincorporated area of the county, and so that's simply what we're doing here.
Is there any further discussion? I have Justice Hires. Justice Hires.
Thank you, Madam Chair. I have some questions because I feel like dissolving the board is a bit, it feels like an overreach to me. And so I'm curious about a couple of things. How many members do we currently have that are out of compliance, that are not, what is our ratio right now?
We have 7 members. 4 are in the incorporated areas of the county, and 3 are, from what my research, it looked like 3 are in the unincorporated areas.
Okay, so you need a majority. So how many members can there be on the planning board?
I believe the law allows up to anywhere from 5 to 12.
Okay, so we could also possibly just add some members to the planning board instead of dissolving the entire planning board? That's a thing that we could do? You could just add 2 more members that would have to be from the unincorporated area. Okay, all right, thank you.
Another option also would be is the quorum court can elect to sit as the planning board itself also. Just to let you know, that is allowed under state law.
I have Justice Coger.
Thank you, Madam Chair. So the law that was cited, that doesn't say that we have to dissolve our planning board. It just says we have to be in compliance. We could be in compliance, like Attorney Lester just said, by adding 2 more people, correct?
Correct.
Okay. And if I understand correctly, only the quorum court can, for due cause, can remove someone from the planning board, correct?
So the law says that a member of the board shall be subject to removal for cause upon recommendation of the county judge and confirmation by the court.
Okay.
The cause here would be that the law changed, and we have an ordinance that says there will be 7 members on the planning board. So the cause is the law changes, and that causes us to have to change the rules that we have, because we currently, under our planning ordinance, don't have a requirement that a majority comes from the unincorporated area. So that's what we're electing to change.
Okay, but I understand what you're saying, but I don't know why we would want to dissolve the board. We have people there who are serving, who have been appointed. Why can't we just add the people to come in compliance and by adding new people, be in compliance?
Well, I think if you look back over our planning board over the years, we've had vacancies because there aren't just hundreds of people lined up, and then there aren't qualified people. I mean, you've got to have people that are qualified to be on the board, and so, getting people to do that, it becomes, a much more difficult task. And so we're fortunate that we're fully, we have all the positions filled right now, which hasn't happened in a while. And so, you know, it's kind of hard to go out and get people that are qualified that can fill those positions. So I think that was the change. We weren't looking to change anything that Washington County has. We have 7 members. We have rules about how many of those 7 members have to do things. So without completely revamping, this was the easiest path forward to just end and then start anew.
So what this comes down to, though, is if this ordinance passes, all the people now currently on the board are subject to being up to the judge whether or not they get reappointed to the new board. Is that correct?
Right. State law says the judge shall appoint to the
Subject to,
planning
yeah, okay.
Yep.
What about the terms? Because they're going to be staggering terms.
Yes, the terms it's listed out how they have to be staggered.
Right.
Which is currently how they are as well.
Okay, well, I'm just going to be honest. I see this as a way of getting around to get rid of some people on the planning board who maybe aren't in agreement with people in authority. That's what I see this as. I don't think we should dissolve the board. I think it's wrong to dissolve the board. We should go ahead and be in compliance by adding other people.
I will say, when this was brought up at the AAC annual meeting, I asked for their guidance. So what's the best way forward? You know, and they said, absolve it and rename them. We, the quorum court, approve. The judge has the legal authority to nominate, and we as a quorum court approve or disapprove of the nominees. That was their recommendation on how to do this. I don't see anything nefarious about following the state guidelines, and they're the ones who changed the rules. I have Justice Dennis, followed by Justice Lemming.
Thank you, Madam Chair. The question I would have on that would be, do we as quorum court have the right to present someone?
If you do, I'm sure the judge would be open and willing to hear, but you need to go to his office and share that with him.
Okay.
Definitely.
So the judge can accept but he doesn't have to accept who we bring forward.
He's the one who nominates them. We're the ones who approve them.
Right.
Okay.
Right. So you're giving up the nomination, is what I'm saying. It takes away the power of the court to nominate someone.
We've never had the power to nominate.
Not taking away any power because we
We
never
have
had it.
Justice. We have County Attorney Lester.
The court doesn't have the ability to nominate anyone. The nomination comes from the county judge, that's it. Nomination by the county judge, confirmation by the quorum court. Kind of like what you see in the federal government when the president nominates cabinet members. You can deny somebody, but you can't bring your own nominees. And that's been the law forever. So it's not a change
That's
in
fine.
anything like that.
Well, I just want a clarification before it happened. Thank you.
Thank you. Justice Lemming.
Thank you, Chair. I have made nominees to the judge, and he's done good and put them on, and he's done a good job. Where are we on our members on when they're getting ready to be took off? I mean, do you have any idea of where they're at right now?
I don't, off the top of my head, I don't know who's coming off at what time, but we'll have members that are up. Every year there's at least one, if not two members that are up for.
So if we elected new members at the end of this year, or whenever they was up, if we had to bring on 2 more, why couldn't we bring them on, right on, and go on?
You could. If you wanted to add and change your planning board rules and add the number of members of the planning board.
Well, no, the numbers can stay the same, the 7. I'm just saying, are there any coming up this year? If we had 2 going off and we brought 2 on that was at unincorporated areas, we'd be in compliance, correct?
Correct. And I don't know where we are on that. I don't know. Yeah, you're right. I don't know where we are on those numbers for this year.
I have County Judge Deakins would like to address that.
The way all of our boards are set up right now are calendar years, and that coincides with you guys' term and, of course, any judges' terms. So we'll have at least a couple roll off at year end, but in the interim, when this takes effect in August, we'll be out of compliance from August until December. So I know there's a lot of insinuation being made about the planning board and what evil plans might be afoot here. I'm appreciative of every one of our planning board members that they are willing to serve. And so, they're going to be, those appointments are going to look a lot of the same if we pass this ordinance and we can get into the quorum court and renominate these people. This also gives them ability, I was having this discussion with Justice Lyons today, the ability to choose not to be part of the planning board anymore. I would like to talk to finding valid planning board members. Justice Dennis, I'd love if you have any names of people who'd like to come help the county. I'd love to talk to them and see if they're willing to help. We do not have a large stable of people willing to be on the planning board. And that's where we're at right now. We already, Dr. Atta gets very frustrated with me and us that a lot of times we don't have a quorum to do certain business with the planning board. So while I understand the knee-jerk reaction to pack the planning board, we would need people to actually pack it with. And so I just have concern about that particular strategy. Thank you, Madam Chair.
Thank you, Judge. I have Justice Massengale, followed by Justice Bruns and Lopez. Justice, and then Lyons, I'm sorry.
Yeah, so when does the law go into effect?
August 5th.
August 5th, and there's not a grace period? The state didn't allow?
This is a grace period.
Okay. I mean, that seems kind of, I don't know, harsh to place that kind of constraint on an existing committee.
I couldn't understand why they even did it, but
Yeah.
somebody did it from another county way, or do you realize the impact it's going to have on other counties? And did you really think this through? So
The other thing point I want to make is, so we've got 4 in incorporated, 3 in the unincorporated. So all it really would take would be 1 committee member from the incorporated area to resign, and then you could replace that with 1 person from the unincorporated area, and we would be in compliance. So I think there's other alternatives other than disbanding and then trying to rebuild from scratch. That's all I got.
thank you. Justice Bruns?
Given the time restraint, I mean, we've got a holiday coming up, July 4th, so we have less than a month really before we get, my suggestion would be that we'd add 2. And the judge himself said that most likely he would add the people that are there currently. So why should we disband? And why don't we just leave them there and add 2 more? And I believe we have to have 2 unincorporated, correct?
Correct.
Okay, yeah. And add 2 unincorporated, and that way, especially if, like the judge says, we're having a hard time getting people to want to volunteer anyway, adding 2 sounds to me like it's going to be a chore. And so what we've got to do is rush out and find 2 people that are qualified to, instead of disbanding, because now we got to find essentially 9. And because let's say some of them don't want to do it again, or some of them won't do it again. I say just leave them where they're at, and then let's add 2, and then we can attrition them out as we go. It just seems like that we're putting ourselves, and Mr. Otta, it seems like we're putting him in a bad position of having to rush around and maybe make a mistake, and heaven forbid if he's, got somebody up there that's causing him a problem versus willing to be a good planner. I think let's just take our time for the next month, add 2 people, and let's go. So.
Thank you. I have Justice Lyons.
Thank you, Chair. So to add 2 members to the planning board, you have to change the zoning ordinance that we haven't been able to pass for the last several months, after it's already been turned back to pretty much exactly the way it's been for years. We still haven't got it passed. We couldn't pass it the last quorum court, got it through one reading, that was it. So that has to be changed before you can add, because in that ordinance, it states, I believe, Counselor, that the planning board is made up of 7 members.
That's correct.
So that has to be changed to 9 if we're gonna add.
That's correct.
So there's a blocker, because by the time we get that done, it's gonna be beyond August 5th, and we're gonna be out of compliance, and what happens if we're out of compliance? The planning board just can't meet, or anything that they rule on is not null and void?
Both, yeah.
Okay. So I don't think that's a applicable approach. I think, again, there's risk either way. You know, as has been stated, we don't have people lining up to want to be appointed to the boards, the planning board, or a lot of boards, right? A lot of effort to go find. You got to change the ordinance, go find 2, or you roll it over, and hopefully those that are on the board will want to stay, and we need to go replace 1. But it's a simple way to replace 1 versus going and trying to just signal out and say this is what we're going to do. So I believe it's the best approach for us to get in compliance, and believe we should pass this on. Thank you, Judge.
Thank you. Justice Pond.
I don't really see where there would be any problem with amending that portion of the existing zoning ordinance, where we could add 2 more people. And I think we have JP's willing to find qualified rural members. And I'm just saying that would be a lot simpler and easier to do than, well, maybe I'm thinking about myself, but it's kind of a good feeling when you run into somebody at some kind of meeting, or you're doing business with somebody that smiles at you and says, "You voted to appoint me to such and such a board." And I'm not sure how well that works going the other way. You know, where somebody walks up to speak with you and says, "Well, you voted to have me taken off the planning board or any other board." And so I'd just be inclined to say it'd be very easy and clean just to amend that number of board members specified in that ordinance. It doesn't have anything to do with changing the entire ordinance.
Well, based on the last ruling from the circuit court here in Washington County, that's a change to our planning rules, and therefore it would require another public meeting. So it's not that easy. That was the decision that we were handed down from Judge Martin in our Eagle Crest case. So with all due respect, the court, at least here in Washington County, would disagree that it would just be that easy.
Just go on. I mean, have Justice Pond?
It's easier to fire everybody on a planning board and start over than it is to change the number of people we can add to that board.
Right, because we're not changing that. We're not changing the ordinance that we have.
And no one's getting fired. I mean, there's times that you have to absolve, to do away with in order to bring it back. You know, we've done that many a time, so nobody's getting fired.
Okay, thank you.
I have Justice Dennis.
Thank you, Madam Chair. Here we are talking about how hard it is to get people, but at the same time, when I think about the whole county, and we're we represent the people for 15 of us to represent the people. It seems like there should be more like 9 people instead of just 7. And can you have a quorum? Can you get business done if you had more people? So would that be something to entertain? I mean, why 7 and not 9? I mean,
Well, that's because when the planning board was created, it was created with 7. I don't think the county's ever changed it. So if you're wondering why 7 over any other number, your guess is as good as mine. That's what the quorum court felt like was sufficient at the time that it was enacted. I wasn't here at that point.
Right. Well, I guess I'm saying if 15, it takes 15 to represent the public, then it looks like we ought to have a few more people on there to represent more of the people. Otherwise, if the ones that are on the planning board are all from the same area, you know, we don't have districts, or do we have districts?
The only thing I would urge you or caution you is time is of the essence right now. So come August 5th, if we don't do something, we don't have a planning board. And so while these are all great ideas, this act was passed back in April. Okay, and these ideas are coming forth today.
Gotcha.
On this agenda.
And got until August to do it.
And we have August 5th to get this done. You're right.
Okay. Well, just wanted to bring it up.
Sure.
Thanks.
And I would certainly say that, you know, if this body wanted to add people, that could certainly happen. But right now, we've got to fix what we've got so that we have a planning board come August 5th.
Yeah. Well, my mind's thinking about the zoning, all the zoning, and everybody wants to be represented right now. And that's the first place that zoning is taken care of, is there. I can see why with as many people as we have and as many districts as we have, looks like we should have more representation on there. But, okay, thank you.
I have Justice Bruns. This is your final comment.
Well, thank you.
Thank you.
Okay, so if we have public comments at the quorum court meeting, that doesn't count as a public meeting.
No, based on what the circuit court's order, that did not count as a public meeting under the planning law. It has to be at a planning board meeting. There's not another planning board meeting.
Can we call one?
Sure, we could try. The last time we did that, we didn't have a quorum, and we had a whole bunch of people show up.
And there wasn't a quorum. Don't you recall?
No.
Oh.
Not since I've been here, we haven't.
Yeah, oh.
Ever since I've been here, we were lucky to find
No.
seats.
We're talking about at the planning board meeting. There wasn't a quorum, and therefore a discussion couldn't take place. And the public was very, very outraged that there wasn't a quorum. My recommendation, Justices, is to pass this ordinance tonight onto the quorum court. Let us get through the legalities of the state and what the circuit judges have shared with us, what they expect us to follow. And if any amendments need to take place after there, you can do it. But this needs to be passed. Time is of the essence, and there are rules and guidelines. If you ought, it's up to you all to decide. I have Justice Stafford.
Thank you, Madam Chair. I guess the one part of this that I'm struggling with is that it seems to me that there are parts of this ordinance that are altering our existing planning and zoning rules, Article 5 specifically, because that's brand new. A majority of the voting members of the county planning board shall reside in an unincorporated area of the county. That's to get us in compliance with state law. But it seems to me that that's altering our current planning and zoning ordinances, so therefore wouldn't this have to go before a public hearing? That's what I'm struggling with here. Thank you.
I have County Attorney Lester or Koger.
Thank you, Ms. Chair. So since I've been sitting here, I've had one attorney send me a text that he's willing to serve on the board, and he's in the unincorporated part of Washington County. And I have a friend sitting out in the audience who's already applied to serve, and she's in an unincorporated area of the county. Just for information, I don't think it's going to be hard to find people who want to serve. And on another note, I don't understand why it's such a big deal that we'd have to amend the zoning ordinance and have another public hearing in order to, maybe I misunderstood. If I did, I'm sorry. You can correct me. But what I was hearing from was that would be an issue because we'd have to amend the zoning ordinance, which hasn't even passed yet. So that's all. Thank you.
County Attorney Lester?
This change is basically a recitation of the state law. We don't have to put this in, but we're required to do it. So it doesn't matter whether we have this in or not. So this is not something that we have to get public comment on. The state has passed this law, and it is the law. So there is no need. Changing our number of members is what we have an option to change. And so the state hasn't said you're now required to have 9 members. Sure, that wouldn't require a public comment or a public meeting because it's not discretionary. That's not a discretionary change. This is state law, and we're simply saying we're complying with the state law as written. So that's why it doesn't require a public meeting. And to JP Koger's comments on, I don't understand why, coming from the JP that has cried that we have to have more public meetings, it's very ironic that you would say that in this meeting, given that you have made a very big deal about public meetings and changing the rules to now say we don't need to. Just
Excuse me,
we've had those. I mean, I've got two people at my house that would love to serve. One is 5 and one is 7. That doesn't make them qualified.
Point of order.
So,
what is your point of order?
That all comments should be directed to the chair and not
Would you,
to
excuse me, would you recognize Chandra Washington, Justice, please?
Thank you. The point of order is that all comments should be directed to the chair and not to individual members of the body.
Duly noted. Thank you. Please direct your comments to the chair. Is there any other discussion? Seeing that there is none, do I have any public comment? Good evening. State your name and where your address, please.
Good evening, Sherry Main, Riches Road, Fayetteville. I don't think we need to take such a drastic step to comply with Act 519. Act 519 became law and was passed on April the 10th, 2025. The judge and the county attorney were aware of this change back in April. And they also were so aware of it that the House Bill 1510, which was also passed, was addressed in the amendments to the revised planning ordinance change. So why did we not address this with the planning ordinance change when we were doing all of those amendments? We still have to have a public meeting on the revised new planning board. The revised planning ordinance and zoning that we still haven't passed because there's been more amendments. So it'll have to go back to a public meeting with the planning board before it can come back to the quorum court to be voted on. So we don't have to make this so hard. We don't have to disband a perfectly good planning board that's doing a great job. The planning board members are paid $75 per meeting. We need to increase their pay to $250 a meeting. Everyone sitting here got an increase on their pay to come to the meetings and represent the constituents in your district. We have 7 board members representing the whole county on the planning board. They get calls, they get emails. They have to deal with the public as well. They don't have districts, but they're still dealing with public comments. I wouldn't want to do that every meeting for $75 and answer 50 phone calls and 50 emails a week. Good grief. You might get more interest from the public if you pay them a little bit more. I personally have applied for a position on the planning board the past two administrations, the current administration and the previous one under Judge Woods. I think I am eligible, I'm qualified. I know the planning and zoning rules front and back, been paying attention for over 20 years, but I'm not a qualified candidate for some reason. We need to get more people on the planning board. We need 3 more board members for the unincorporated area for a total of 10 that would meet the majority rule and be in compliance. Pulaski and Benton counties, which are also the larger counties like we are, Washington County, have 10 on their planning boards. We can have up to 12. What's wrong with 10? That's a round good number. We just have to add 3 more that are in the unincorporated area. And as J.P. Coger mentioned, you already have 2.
Thank you for your comment.
Find another one and let's get this done.
Public comment. Good evening, sir. State your name and your address, please.
Yes, ma'am. Kenneth Lovett, 18702 Clearwater Road. Bad planning on your part does not constitute emergency on mine. This was known in April. Why is it just now brought up? Just because it's the last second? This Act 519, it simply adds to the current statute. Majority of the voting members of the county planning board shall reside in an unincorporated area of the county. It does not direct nor authorize nor recommend dissolving and then reconstituting a new board. Arkansas law requires cause, written notice, due process, and quorum court approval. And if you'll go and read the bill, the actual bill, it was a Senate Bill 324, and this was documented on 3/28/2025 at 1341, and I'd like to read it. It says, "For an act to be entitled, an act to amend the law concerning the membership of the county planning board and for other purposes." The subtitle is to amend the law concerning the membership of the county planning board. Be it enacted by the General Assembly of the State of Arkansas, Section 1, Arkansas Code 14-17-203, concerning members of a county planning board, is amended to read as followed. A1, with the approval of the majority of the members of the county quorum court, the county judge, and any county may create a planning board. It does not say shall disassemble what you've already got. Number 2, the county planning board shall consist of not less than 5 members, nor more than 12. We have 7. We have the biggest growing county in the state of Arkansas. We need more representation. We need 12 people. There's people around. Who is it that says this is who is eligible? Just because you don't have a piece of paper don't mean that you're not smart enough to handle the job. 12 members appointed by the judge and confirmed by the county quorum court. And we had a discussion a while back that the judge didn't want to be questioned, and we need to go back and add that amendment to that, where it is all things come before the board, not just his opinion, because the judge that we have now, in my opinion, is a child in his actions.
Excuse me, sir.
I'm speaking to you.
Yes,
Yes,
and I don't appreciate those disparaging
and
comments.
I don't appreciate a lot of things y'all do either, but that don't change it.
But I don't sit there
Number
and
3,
disparage
at
you,
least
sir.
1/3 of the members of the county planning board
Thank you
shall
for your
not
time.
hold any other elective office or appointment.
Thank you for your
Except
time.
membership.
Is there any other comment? Thank you. Sir, your time is up.
It's 6:59 p.m.
Thank you. Public comment. Ms. McKinney, thank you for. Thank you, sir. Good evening. Could you please? One moment. Once it turns red.
We are. Hey, my name's Mary McKinney. I live at 19980 Lakeview Road. Why is this just being brought up now if this law was passed in April? You all, thank you for the additional questions that you've had. Sometimes I feel like you don't get the information, all the information you need to make the most fully informed decision that you possibly can. I think sometimes you get the information that is chosen to be delivered for the decision that administration wants to have. You're getting painted in a corner. This law was passed in April. Why is this an emergency ordinance now? Why is it just being presented? Personally, I'm affected by the Eagle Crest decision. Yes, I don't think it's a fair comparison. It was an emergency ordinance passed without any notice to the people involved, myself included, without any notification. Same thing tonight. Why? Why is this just now being brought forward? You're painted in a corner. You're given only the information up front until you ask the questions to get the decision that administration would like to have. And I value very much you digging deeper and asking the further questions, and I thank you for that.
Thank you. With that, we're going to take a vote on ordinance 8.1. All in favor, say aye. All opposed? No. This ordinance fails. Moving on to item number.
Madam Chair, I normally don't ask for this, but could we not have a hand vote or where we can call for a show of hands?
Microphone, please.
Well, I'll keep that. It was close in your.
I said it was close.
It was close.
I wouldn't know how to discern the two, so. Point of order, please.
The ruling has already been made that what we'll do next time is, it was obvious to me that it was that the ordinance. Pardon, go ahead.
Point of order, please.
Okay, you can call for a division of the assembly, which will call for a rising of the vote, and instead of rising up in Robert's Rules of Orders, edition number 12, you can just raise your hand. I have Justice Wilson.
I had a point of order. If I'm incorrect, I'll be glad to be incorrect. I don't know if we ever had a motion to move this ordinance to the full quorum court with a due pass recommendation, or did we?
Yes, sir, we did.
Okay.
And a second.
Yeah, a lot has happened since then. Thank you.
All in favor, raise your hand. And we're in favor of ordinance number 8.1. There was a division of the, okay, we have 1, 2, 3, 4. All opposed? 1, 2, 3, 4, 5, the majority. The motion fails. By show of hand, it's accepted. Thank you. Moving on to item number 9, ordinance enforcement discussion. County Attorney Lester, please.
So at the last quorum court meeting, there was a question that I think was presented by J.P. Bruns about ordinance enforcement and how that works. And so I want to discuss that briefly and answer any questions that anybody might have. As the legislative body, you're the one clearly that passed the laws here that are for the county. When it comes to enforcement, enforcement falls to the executive branch. Under that, you have the county sheriff, who is the enforcement arm for the county. And so violations of county ordinances would fall to the county sheriff unless we were to have like a code enforcement. Well, Washington County doesn't have any code enforcement. Some cities have code enforcement that handles some of their code enforcement. We can look to the cities of Fayetteville and Springdale. They do have some code enforcement when it comes to codes, building codes, that sort of thing that they follow. Washington County doesn't have any building codes. But when it comes to the violation of their ordinances, it's their police departments that actually issue those citations. And so that question was raised, and I wanted to be able to answer any questions that anybody might have about the enforcement and how that happens. When it comes to conditional use permits, my office will initiate legal proceedings if the enforcement piece is not working. In other words, we have people that are keep violating. We've asked them to come into compliance. They won't. And we go down that road, and we have several of those going on right now. The only issue with that is sometimes, as you are all aware, the wheels of justice grind incredibly slow. There's a lot of processes that have to be allowed in order to do these things. And so oftentimes from start to finish, we're looking at over a year or more whereby somebody is in violation of our rules. And so it is a very, very slow process. That's one reason that we look to change the violation fines for people up to the maximum amount, because $200 a day for some of these violators is not a big deal. $1,000 a day starts adding up a lot quicker. And so that's why we're doing that. So I just wanted to kind of let all of you know kind of how that works, and then answer any questions if the chair will allow.
Yes, I have J.P. Bruns.
Thank you, Madam Chair. Well, the reason I brought that forward is because there's seems to be a discrepancy in how that's administered in this county. And that, for instance, when I got the complaint on Kenneth Price Road, I didn't just get one, I got bunches. And so I got with the sheriff. The sheriff went out, looked at it. He talked to me the next day, said he gave you the information and that you were going to write a letter. Most people never got a letter.
I'm not aware. I'm not sure what you're talking about on Kenneth Price Road.
Well,
but if you want to talk to me
the
sometime.
sheriff, he can tell you.
Okay.
Because they never got a letter. That place has been a junk fest for, I mean, there's trees growing up in cars that haven't run in years. They got dirty toilet paper running across the street into people's yards. Dogs that attack people. And nothing. They call the judge's office, get hung up on. So they say, okay? They call, leave messages. Nobody will call back. What I was trying to get at, Mr. Lester, is that our system is not working.
And I understand that, J.P. Bruns. I am not I don't have the authority legally or otherwise to enforce anything. My enforcement comes from getting court involvement and asking a judge to issue a ruling ordering someone to do something or refrain from doing something. That's a year or 2 year long process if we're fast about it. And it's a speed that I don't have control over necessarily. So a letter is not enforcement. So if you thought that a letter was somehow enforcement, it's not enforcement. That's not how our ordinances are enforced.
Well, I didn't think anything. I thought that sending this letter, at least they would get it.
We send letters pretty much to everybody before we file a lawsuit. And in the time I've done this, I don't know that any letter has ever resolved the issue.
Well, do we get signatures for those letters?
Like certified restricted delivery?
Correct.
No.
Well, it'd be a whole lot cheaper than a lawsuit.
Well, that's assuming that these people are going to comply with the law that they're already breaking. That's like sending a letter to a drug dealer and asking them to please stop selling drugs.
You're way off base there, sorry.
Okay.
Sorry.
Are there any other questions regarding the enforcement of ordinances? I have Justice Lemming.
Thank you, Chair. Brian, that's a tough question. How could we change how we police our ordinances to make it better? Because we really don't have a lot of teeth in the fight sometimes. I mean, we really don't. And how could we change to make that better?
So under state law, all you can do is issue a fine up to $1,000. I mean, that's the limit to your authority as a quorum court. You cannot require jail time or anything like that. And so all you can do is increase that fine and have those people issued a fine for every day. That $1,000 will eventually add up. I mean, even these guys operating these big dirt mines and rock quarries or commercial businesses out of compliance, $365,000 is a lot for those guys. I mean, that's that $200 a day, not. So you're working on it. We're working on that. That's part of this ordinance that's pending. That was one of the few minor changes, was that fine went up to the maximum amount in order to try to get that, because that has a bigger sting than the $200 that we're currently operating under. And for some people, $200 is enough.
Yeah,
but for some it's not. But unfortunately, that's it. I mean, that's where the line's been drawn by the legislature.
So basically, you're saying the only thing we could really do is just up the ante on the price of the fines.
And then be issued a fine for every single day they're in violation.
So when you do that, when you fine a company, that means your police officers has to go to court every time they have a court in different courts scattered across Washington County.
That's correct.
So it's going to cost the county money on that side as well as on the citizen side as well.
That's correct.
So to Mr. Burns' question, though, on a little deal on a cleanup, so you're saying if we send them a fine of $1,000, it's going to help more than $200. But there again, if you take them to court, if it's $200 and you go to court, what's it cost your law officer to be there all day with them at $200?
So on an issue of a junkyard cleanup, there is enforcement through Boston Mountain.
Correct.
And Boston Mountain has Officer Carnahan, who can go out and do investigations. He's a law enforcement officer, and that is what he does. He is a certified law enforcement officer that issues citations and does that. And so on those types of things, we can get somebody, an enforcement officer like Officer Carnahan, to go out and actually take that case. We as the county have never had a certified law enforcement officer that could operate in that capacity just for environmental concerns.
Well, when we had our environmental guy hired, besides the ones at Boston Mountain, we could.
They were not law enforcement officers.
So that's why we got rid of them and turned it straight over to Boston
That's correct.
Mountain.
They did not have the same authority that Officer Carnahan has, somebody in his position.
Okay, thank you.
I will say that if there's a vicious dog out there that's attacking people, we have vicious dog laws against that. And you call the sheriff's department and say there's a vicious dog attacking citizens walking by, and they will enforce that law. Thank you. I have Justice Rio Stafford.
Thank you, Madam Chair. I just want to clarify this also for the public, because I think I just want to highlight this, that the new proposed planning and zoning ordinance, the one that we've been going around on for 16 months now, one of the few things in there now that would change if we do pass that planning and zoning ordinance is that we would have a stronger enforcement mechanism than we do today to go after folks who are violating our ordinances in terms of CUPs and things like that. That's what's included in that planning and zoning ordinance, is increasing the fines up to $1,000 a day, which we don't have right now. Correct. It's a much lower amount. So if we do pass that planning and zoning ordinance, that's one of the benefits that we would have passing that, is that we would have stronger enforcement against folks who are violating the law.
That's correct. Along with, we have removed the portion that is in there that has, I think, been in there since the 90s that says once an appeal has been filed, we can no longer issue a fine. And so we've removed that so that these appeals can't just keep people from accumulating fines. Now, they may not pay it all, but at the end, we get to a favorable decision by court. They have accumulated a fine over time. The court can then impose that fine that they've not paid as part of that order.
Okay, so it would get rid of the freeze.
That's correct.
That's in place when something's being appealed
That's
as well. So that would also strengthen our enforcement mechanism as well.
Yes.
Okay, thank you.
I have Justice Lyons, followed by Rivera Lopez, and then Justice Massengale.
Thank you, Madam Chair. Just when I started in my first term, the question I had was compliance of the ordinances, because we had a place out on 412 that was ugly. It needed to be corrected. So I inquired about that, and basically it's formed how we conduct ordinance compliance through complaints. So you file a complaint. If I know it and I file a complaint, I file it with the planning department. They coordinate with, I believe, Counselor Lester, and it goes through a process of, going out and seeing them, talking to them, making sure they understand they're in compliance with ordinance by not having a cup, or in this particular case, they have a cup, but they're in violation of their cup. Been working on that particular one for 2 years. Because again, being respectful of the citizens, we went to see them, they said, yeah, we'll do it. So you give them time to cooperate and become compliant. If they don't, then you do another complaint and you see them again. And I think in this particular case, there were medical issues with the owner and he was out of the country. I mean, there were all kinds of things, right? So I think we're at a point, hopefully, that we'll see next steps made for that particular one. It's been going on for a while. We got another one, and I had to explain this to that gentleman because this gentleman has continued to try to divert the fact that he does not have a cup, and he's operating a business. And I think his business is very unhealthy for his neighbors, quite honestly. And just had a conversation with this weekend, same conversation. He wanted to say, well, this gentleman over here doesn't have a cup and that one over on that. Well, that's fine. Make a complaint. We don't have people that drive around the county and say, hey, they don't have a cup. We need to go start, working that process. It's all driven by complaints. Whether it's a JP making a complaint verbally and working through the process with Director Ada and the counselor, or it's a citizen making a complaint to the planning department and moving it through the process. Normally when that's made, it's in my district, I get notified as a JP. Then I try to look at, watch it, shepherd it to see what we can go through. So just, again, my experience of what I've experienced for, 3 years being in this position, into my 3 years. So if that helps in the future to help resolve this, that's great.
Thank you. Justice Lopez.
Thank you, Madam Chair. I suppose my question is really regarding, so if someone were to fail to pay their fine, does the county then, is there like a garnishment process where we then garnish wages? What exactly does it look like if someone fails to comply with a fine?
Well, those all go through the district court. So the court actually imposes those fines and orders those fines to be paid.
Understood. Thank you.
Justice Massengale.
You mentioned earlier that we had some active, lawsuits at CUPs.
Some what now?
Active lawsuits, active litigation. Is there a way, or where would we be able to find, information on current cases?
So everything that's filed in the courts if you go to the Arkansas Judiciary website, it's got Court Connect. You can look pretty much any case up in the system. They're all public. All the filings and everything are public.
Okay. Would it be possible to get a report or something, kind of showing all the active cases that we have currently ongoing?
Yeah, I'm sure you could get a report. Court Connect has all that information.
Okay. All right, thanks.
Thank you. Is there any other discussion? Okay, we're moving on to item number 10, Fuel Island discussion. Who is bringing this forward? Chief.
Good evening.
Good evening.
So,
please state your name so everybody will know who you are.
Michael Stewart, I'm the
Thank
Chief
you.
of Staff.
Thank
So we're proposing a new fuel island for the county. The current fuel island that we have at the road department for the diesel fuel and the unleaded gasoline there is 20-plus years old, out of date. We can only purchase through one vendor for the fuel because it's leased through, I believe it's Frost Oil, so we don't get to try to find the best price on fuel or anything like that. Just twice this week alone, we've ran out of fuel, or I'm sorry, this month alone, we've run out of fuel because they weren't able to come to us. We can only purchase through one company. So what we're trying to do is upgrade this. We have 2 pumps there currently. The upgrade would get us up to 8 total. This would also serve, like it used to do years ago for the sheriff's office. It'd be something for all county vehicles, so we're not having to purchase fuel, whether it be diesel or gasoline, around at different convenience stores at wherever the price is. We can get it at hopefully discounted prices. It's going to help us with budgeting on that. We can try to work out a budget process for the fuel that we're going to be purchasing throughout the year. Like I was saying, it's 20-plus years old right now. It's a dial-up modem for all this to work. It goes down. We had a lightning strike here a few months ago, and the phone lines were down as we were fighting back and forth between Cox and AT&T because of issues that we have amongst those two. We finally got it back up. We've got, I believe it's 1,500 transactions that we can use before everything must be downloaded. If that's not done by then there's no more fuel that we can get from our own pumps. So what we're proposing is sending out bid on getting a new system put in there. It'll be larger tanks, along with cloud-based uploads, things like that. So if they come out, they can just keep it full for us. This is going to help us out. One of the main things that I'm excited about is any sort of emergency event that comes up, whether it be weather or anything else like that. We've got fuel on hand for X amount of time, however much we need for our law enforcement agency, for fire, ambulance, whoever needs it, we would be able to provide that to them for the community. It's also something that we're looking into getting it at the Morrow area as well, at our crusher out there. We currently have a diesel tank out there, but it would, a little bit extra on that, we could put it there so that our sheriff's office deputies that are out in the Morrow area, out around that area, if they need fuel, they don't have to come all the way back to town or drive into Lincoln for something like that. They have access to county fuel that's there as well. So I believe you all have some talking points here on this. But the main point that I wanted to hit on this is just the readiness on the emergency preparedness for having this access to the fuel here whenever we needed it. So.
Are there any questions regarding this discussion I have? Justice Lemming?
Thank you, Chair. Fuel is one of the most expensive things that Washington County deals with and will deal with. And I think it's been crazy that we've been in bed with one vendor. That's absolutely nuts.
I agree.
Because I bought fuel as low as $2 a gallon. And that's from my company over in the Berryville area. There's a company out of Rogers, Agland Fuels, that travels everywhere. They're beating your price terrible right now.
Yeah. Well, these are averages from the year so far. So. And it's no doubt that you have to have a new fuel system because 20 years, it's kind of like an air conditioner. Fuel systems don't last. Right. They don't last that long. So you definitely need a new fuel system. Is these going to be above ground or in ground tanks? In ground.
Okay. So that's a lot harder to maintain and keep up with for the Arkansas Department of Environmental Qualities, and you have to stick it, and you have to maintain it, and that's a big apple to chew too. It takes personnel good for that. I want to see you go a little further with your diesel tanks in the back of your pickups. Okay. Because there's horror stories that I know a lot of people, and I'm not saying you got thieves that work for the road department, but I know of thieves that you've had that work for the road department. When I worked for the state highway department, we had a tank in the back of our truck that had a number on it, and you put X amount of gallons in it, and you had a little stick so long, and you stuck it every time you put fuel in a piece of equipment from one to the other. And I think that's a step you need to add, make sure that gets in this same situation here.
Well, I mean, it's very unfortunate. I mean, it's I hate to say it, but unfortunately we have thieves across the county outside of just the road department potentially.
And I like the idea of the sheriff's department going to be involved in this, because I've talked to Jay a little bit. He's kind of excited about
All-
it too.
all county vehicles,
Well,
so-
that's very true, all county vehicles, and so, but I really believe you need to, either if you have to meter your tanks and your pickups, or whatever you gotta do, we need to keep a better record of
I
our
agree with
fuel,
that.
because I can tell you some horror stories in the past, but them people's dead and gone, and they're out of the system now, so we don't have to worry about that, so. But I think it all looks good, and I know it's expensive. You can't do nothing for cheap anymore, and I really believe that what you got going here needs to happen. And there's probably more talk about it, but I'll move it to the full quorum court to pass.
Well, it's not a motion, this is only a discussion.
Okay.
Just bring it forward.
I'll make a motion.
Yeah, this is just some talking points. We
This
want
is
to make
just
sure that
talk-
you were
yes,
all
make sure.
aware of what we were wanting to do.
Okay.
This will probably come down through the budget process.
Correct.
I have Justice Ricker.
If the sheriff's office is involved in this, it's not going to take away the current system they have where the deputies can buy fuel in Lincoln or wherever they need to.
No, sir. All county vehicles will still maintain their same purchase card for the fuel.
Okay.
So
I just
that
want
if
to make
they're
sure
out and
that
about-
a deputy's not going to have to come all the way into
No.
Fayetteville to get.
No, it'll be preferred that they purchase or get the fuel from the county pumps because it's a better rate that we're purchasing for. But nothing's required because they may be out of town, it may be the transport division that's traveling across country, something like that. Obviously, we got to keep the purchase available for.
Okay, I have Justice Lyons.
Madam Chair, will this be available to all county vehicles?
All county vehicles.
So not just roads, not just
Not
sheriff,
just
all
roads,
county
not just
vehicles.
sheriff, every county vehicle is what we want to be able to
And then,
utilize
you
this.
know, I think I agree with my colleague that this is needed, something we're gonna have to look at and do. And there's a lot of numbers here.
Mm-hmm.
You guys have an estimate of, surely we're gonna save money ultimately. Any estimates what you think we'll save? And maybe not now, but is that something we can look at?
It's hard to say because we don't know what the fuel prices are going to do.
Well, I understand.
So, but overall, purchasing our own fuel in bulk
Yep.
is, I mean, I can't see how we wouldn't save money on that.
Again, I'm not trying to disparage it, right? But
Right.
it's just the gravy, right? If we can make some assumptions and get some estimated savings, it just puts gravy on top of everything else that we're here. So I'm just curious. Thank you, sir.
It was Justice Stafford, followed by Justice Slimming with the follow-up.
Thank you, Madam Chair. JP Lyons kind of stole my question. This sounds like to me, it sounds like a good idea. It sounds like it's needed. I was hoping that maybe, obviously there's a cost in constructing this. And I was just wondering if, we could do some estimated numbers on, at what point, like in what year we may see, okay, now we've broken even, now we're going to start seeing return on investment after year 5 or whatever.
I'm sure that'd be
Yeah.
very difficult, but
Yeah.
I'll get with Paul on
Yeah.
that and our comptroller and see what we can't come up with as far
Okay.
as future projections for
Yeah.
that, absolutely.
Okay, thank you.
Let me jump in here real quick. If I get up here in front of you, ladies and gentlemen, it'd be to brag. It'll be on our team. And so some of those numbers you're seeing there, the top there was the cost estimate that we've put together, horseshoes and grenades with the vendor we've been talking to right now just to get some consultation. This will go out to a full bid. But I also want to brag on our purchasing department for a minute. I had said at the last quorum court, we want to continue to bring you guys savings. We're very laser focused on that right now in the purchasing department, looking at all of our contracts with the support of the legal department to see if there's savings and efficiencies. And what I want to say to you guys tonight, we took our property insurance. You all know where we've been with that. It was $1.2 million premium for this past year. We have talked to our vendors. We put that out to bid. That went down to $400,000. And so what I want to tell you guys is that's what happens when you stand up and you have good, knowledgeable people that can negotiate on behalf of the county. And so how does that connect to this conversation? We want to try to invest those funds like that into capital projects for the county that will serve us well. Chief of Staff did a really good job of highlighting it, but what I want to do is do a couple more improvements here. We have 2 pumps that are a sad excuse for gas pumps right now. I mean, they really are. Something has got to be done anyways. So what we do is we look for how we can grow as a county, how we can be one as a county, and how we can save as a county, and that's what's driven this process. And so we will work on those numbers as much as you can. Some of the difficulty is the off-site fuel purchasing that we do and getting that information fed back, predominantly from the Sheriff's Department right now, which that functionality will still be there. But also what I want you to know is this is a readiness issue for us in terms of first response. It's no news to you guys that we're building the EOC down there. That's going to be a hub of emergency response when that starts. And so it's not just us that might be fueling up. It might be other first responders, because we all know ice storm of 09 or whatever you want to fill in the blank. We're competing with the consumers too at the pumps if something were to happen and there's a run on fuel. And so we want to have that. Another one of the big things that we're looking at right now, we currently have 10,000 gallons of fuel at the road department, half unleaded fuel and half diesel. We're wanting to expand that to about 24,000 gallons. That will accommodate the Sheriff's Department, but also it will keep us ready in times of readiness. So we don't want that tank to run empty before we're calling that vendor, if that makes sense. We're wanting to always top that fuel off in case we get in a bad spot and have to make a run on that fuel, and of course share that with maybe some of our first response partners. Justice Lemming talked about it. I cannot tell you how difficult it is when a vendor knows they own you. It has been extremely difficult. This vendor right now, I've appreciated, I guess, their service to the county over a number of years, but they absolutely know they own those pumps, and they absolutely know that we have no other choice. And so this allows us now to daydream. We've been talking as a county, if we could get this off the ground, we want to put this fuel out for bid continuously, but we might also contract. We might get a set price for a year and contract underneath that, and that would help us with budgeting. All these are what-if possibilities that we have no room to talk about right now because we are completely beholden to the one vendor. I'll share with you in the February of 23, storm response is always difficult. You're asking your road department to go out in difficult snow conditions 24/7. And during that time, we had our fuel freezing on us. And that's very difficult on machinery and the men and women who are trying to operate that machinery. And so all that to say, we want better service providers at a better price. And we can absolutely do that because our purchasing department just showed us that they can. Thank you.
Thank you, Judge. I have Justice Lemming.
Thank you, Chair. Mike, I was going to talk a little bit about that. Are you going to try to not bid it per year, or are you going to just try to bid it monthly? Or are you going to try to look at it however?
Whatever will be the best process for the county to save the most money.
Fuel prices change every day.
Exactly.
I mean,
so it'd be tough to. We'll have to see what their options are.
And normally, whenever you go to a new fuel item system, whenever you fuel a car, you put mileage in with it. When you fuel a grader, you put hours in with it. So that'll be easier to track hours on graders versus gallons of fuel burning that grader,
right?
As well as your cars and stuff. So
that's all tracked on that. We'll enter a code, basically the employee ID number, along with the vehicle unit number, mileage or hours or anything like that. That's on the equipment.
That's the way my cards work.
To track it.
Do you have any idea? I know you talk about keeping these cards. Do you have any idea of what the card costs the county per year to use?
I do not have that off the top of my head.
And you could save that number. More people use your gas pumps. You won't have to get paid. You won't be charged for the credit card use on every card every time you buy fuel. So therefore, that's a big savings for the county. That'd be a good number to know. That'd help this fuel deal a little more. Thank you.
Sir.
Thank you. Is there any other discussion? Thank you, Chief. We appreciate it. Next on the agenda is item number 11. This is an open discussion on industrial wind farms. I will say that it has been said that you can't stand in the way of progress. We have some of the members leaving the courtroom. Thank you. It has been said that you can't stand in the way of progress, but I say that beauty is worth preserving. Protecting our natural landscape is not just an environmental issue, but it's also an economic and social one, requiring a multifaceted approach that includes good and intelligent zoning for proper planning and future growth. Number 2, preservation and protection of our agriculture industry, which Washington County is the state's leading producer and top county for the dollar value of agriculture products produced. Number 3, protection and preservation of our land use, state parks and natural reserves. To address these challenges, we must focus on passing our zoning and planning ordinance, ensuring preservation and protection of our land use for present and future generations. This is an open discussion for our citizens of Washington County to share with us their views on wind farms. There's no action that will be taken. What I would like, if citizens want to share their comments, you could have on the right side those who are opposed to wind farms, on the left those who are for wind farms. I would like for you to state your name, your address, and who your JP is. This is very important.
Point of clarification.
What's your point?
My point of clarification is, are we talking about item number 11, or are we talking about item number 12 that I placed on the agenda for the concerned citizens of the Ozarks?
I said item number 11.
That's not the concerned citizens then?
No, this is an open discussion for wind farms for Washington County residents.
Okay, I wasn't sure, but thank you for explaining.
You're welcome. Okay, we also have a maximum of 3 minutes to explain your point of view, whether you are for or against wind farms, or you can simply state, I'm not for this. I don't want it to trash our beautiful landscape. We will also not discuss any moratoriums or legal issues regarding wind farms. I will have that. What's your point? Put your mic on.
My point of order is that I don't think the chair has the authority to declare to people what they can and cannot say.
I'm the chairman, yes, I can. These are guidelines that will be abided by.
Under what authority, Chair?
Mine.
That's not gonna.
Thank you.
That's not authority.
There's rules of conduct. So we will not discuss moratoriums or legal issues. Based on the state legislature who passed Act number 945, they already established the comprehensive regulatory framework for the development and operation of wind farms. With that, I open this up to our Washington County residents to discuss whether they are for or against wind farms. Okay.
Want me to push the
Thank you.
button?
Nope, you're already on. Just push this down.
Thank you, Chair Ecke, for giving the residents of Washington County an opportunity to have this discussion. I'm Nikki Lockett. I live at 12283 Greasy Valley in Prairie Grove, and JP Ricker. Gary Ricker is my JP. I do not support industrial wind power plants in the Ozarks for several reasons. One is the karst terrain that we have, which is made up of limestone, which can easily, it's typically soft, and we have a bunch of caves, caverns, and susceptible to sinkholes. I mentioned several things in the Quorum Court meeting last week. I think we need time to be able to study the health effects with a bunch of things, the watershed impacts, the groundwater with water wells, spring water, the bats, the eagles. I'd like to understand what the net clean energy impact is. Like, people tout what the benefits are, but to mine the rare earth minerals that are needed, like the magnets for the turbines, most of that, 95%, I think 95% of that's done in China. And I think it would be good for us to understand how those are mined, and is that very environmentally safe? And I would guess probably not. Two, I think we need to understand the roads, the impact to the activity and the traffic of an area, since they are small communities, the true lifespan of the blades and the total turbines. When there's oil spills, what kind of impact does that have? I know there is Act 945, but what happens if these companies file bankruptcy or dissolve? If the tax subsidies go away and these companies no longer exist, and who's responsible whenever they do get decommissioned or they need repair? We'd hear about property rights, but utility companies work with service agreements with these wind energy farms or wind energy companies, and they do things such as generator interconnect agreements, facilities construction agreements, which the utility companies can go and enforce eminent domain on the property owners who do not sign property leases. So what happens to their property rights? If there's sinkholes that occur because of the terrain, and if it's done on somebody that didn't sign a lease, what happens to their property right? In Missouri, Ameren High Prairie was commissioned in 2020. It's the largest wind power plant in Missouri. 3 turbines collapsed in 2024 within a 6-month time period. They were Vesta blade detachments that caused imbalances in the turbines, causing the collapse. Most of the 175 turbines remain shut down as of March 13, 2025. I would encourage you, if you want to get the true feeling of infrasound, is go where there is a wind energy power plant at 2 a.m. in the morning when people are trying to sleep, and that low frequency wakes them up. And if you want to see the damage done to roads, as an example, in Carroll County, if you go to County Road 905, that would be a really good example. And then really in these rural areas, it creates fractured communities for generations to come. And I really don't like my U.S. tax dollars subsidizing these foreign-based companies like the one that's looking at the Lincoln area right now. Thank you.
You're welcome. Good evening. Please state your name, your address, and who your JP is.
Good evening. My name is John Minotti, and I live on Borchardt Road in Washington County.
Do you know who your JP is?
My JP is Willie Lemming, yes. Thank you.
Thank you. It's Justice Lemming.
Justice Lemming, yes. So this past May 15th, I did speak before the Quorum Court regarding the RES turbine project that's targeting this area. Since then, I know many community members have spoken up and expressed their concerns about this proposal. At the same time, we've seen RES representatives, they have written to and also spoken to the Quorum Court, promoting what they describe as the many benefits that this industrial project would bring to the community. In reality, these benefits are not really for the people of Washington County. Landowners will receive a few $1,000s as opposed to the hundreds of thousands of dollars that each of these turbines will generate. The benefits are really for the investors and the corporations. Our own federal government has recognized this imbalance. If you're not aware, the national spending bill will be on its way to the president's desk to be signed this week. It includes language that specifically is designed to shut down all future wind turbine projects in the United States. The spending bill clearly states that wind projects like the ones proposed by RES are no longer in line with national energy priorities. These wind projects were only going to work because of the government handouts, which is the subsidy, and this bill ends those handouts permanently. Any forward motion by RES at this point is just a rush to get in under the wire to get any federal money so they can for a project that they know is not going to be successful. The U.S. government currently sees wind turbines, the industrial farms, as destructive. And to that point, we're going to deal, and the Planning Committee will deal with such things as ridge leveling. And this is to support these 250-ton turbines. They weigh 250 tons each. It's going to require blasting, flattening the top of the ridges, permanently reshaping the land and increasing the risk of erosion and runoff. You're going to have to deal with road widening and construction that's to move these huge turbine parts. If you look at the news today, you'll see that one of these blades fell off of a truck on a highway in Washington County, Maryland. It blocked 2 highways going both ways. The roads are still shut down for today. So here, new roads will be created through the woods, the hills. You're going to have lasting environmental infrastructural damage. You're going to see miles of land trenched to bury these cables. The trenches are going to cut through farms and forests. Of course, they're going to cut the root systems, killing trees, and you're going to have long-term damage to soil and vegetation. Property value. So homes within 3 or 4 miles of the turbines will lose up to 40% of their value due to the noise, light flicker, and so on. With the new federal restrictions addressing such destructive projects, it just doesn't make good sense to pursue them. If you need further proof, just take a trip to Carroll County, and you can see it for yourselves, the destruction. I promise you that in the long term, we will join the huge list of counties that severely regret allowing similar turbine projects in their community. Thank you for your time.
Thank you. Good evening, Professor Landry. Excuse me, would you state your name and who you're JP?
Well, you just said it. My name is Michael Landry. I live in District 1. Bradley Bruins is my JP. I live at 2992 Wright Avenue in the Harmon community. One of the things that we think about when we think about environmentalism is it is usually utilitarian. It is about clean water and clean air. And as I look around the room, some of us have enough gray hair to remember the bad old days when we didn't think about those things. But one of the things that we don't often talk about when we talk about environmentalism is the whole thing of aesthetics. We live in the Ozarks. We live in the natural state. Now, how do we address these sorts of wind turbines? Well, it says right here in the agenda, we're talking about industrial windmills. This is to be addressed, I assume, through zoning. Would you like to have an integrated steel mill located in Washington County? That's heavy industry. It's necessary. But as we look at the things regarding the wind turbines, I'm of the opinion it is sort of a fad, because what we're finding out, to speak from a utilitarian standpoint, is the cost benefit of a wind turbine. Sure, we'll have some clean air while generating electricity, but the environmental cost of building it, transporting it, lubricating it, maintaining it, and then after its life cycle, dismantling it, we're going to find out this is going to be a fad. Why should we get into it? So if it's to be addressed from the standpoint of a zoning ordinance, we need to think about natural things going on in our natural state. We are a big habitat for eagles in this area. We are near the Mississippi Flyway from the standpoint of great migrations of birds, which take advantage of our environment. And what do we know about birds and wind turbines? If you'd like to make an impact on it, think about what we see when we see birds encased in oil slicks because of the oil industry. It's the very same thing from the standpoint of dealing with our natural life here in the Ozarks. We're dealing with the aesthetics. And I don't know if this is still the case, but I know a lot of these wind operations have been heavily subsidized in order to try to make the rates competitive. Again, I'm not sure if that's still the case. So I don't think this is something that your zoning ordinance that you're working on should allow for us in Washington County. Thank you.
Thank you. Are there any other Washington County citizens that would like to make a comment for or opposed to wind farms? Seeing that there is none, I would like to state that the company, I don't know who they are, in favor of these wind farms did not contact me, and I don't know who is. That is up to the county judge and through the quorum court to bring that to our attention. This was all intended for our citizens to have the opportunity to share their concerns, their thoughts, their ideas on what would it be like to have wind farms across Washington County. And I appreciate everybody's contribution to the discussion. And I look forward to having more discussions on different items. This went very well, and it was greatly appreciated, everybody's input, respectful input. Now I open it up to the court. I have Justice Stafford.
Thank you, Madam Chair. The company that's looking into potentially building a wind farm here in Washington County invited the Quorum Court out to one of their community meetings at the Cincinnati Fire Station back on June 18th. And I made the drive out there, about a 45-minute drive from my home in South Fayetteville, beautiful drive. And I wrote up a little bit about it. I just wanted to kind of share some of my observations from there. There were a few dozen people at the meeting. They represented a range of opinions from pro to con, including some folks who were just there to ask questions and get more information. I found the folks from RES to be very forthcoming with information. They had answers to many folks' common concerns about wind energy, including birds and bats and things like that. I also learned that any potential project is many years away, possibly 2029 or beyond. Their first step is to make agreements with private landowners, and then only then can they start conducting testing on private land to see where and whether wind energy is even feasible. According to RES and other sources I've looked at online, there are only 2 spots in Washington County where there even has strong wind energy potential. One is the area kind of northwest of Lincoln, going up almost towards Siloam Springs, that area right in there. And the other area is near Winslow. But only the Lincoln, Summers, Cincinnati area is part of this project. Our role is basically limited to, at least under our current rules, if this company decides to move forward with landowner agreements and they have positive test results, then at some point in the future, landowners may come to us requesting a conditional use permit. And that would be the Quorum Court's role in this. A few questions had to do with, related to the county that some residents asked. One had to do with county roads leading to some of the potential sites, whether those county roads might require improvement, and if so, would taxpayer money be spent? The company indicated that they would pay for any improvements to county roads and that they would improve the roads to our county standards and specifications as laid out in our ordinances. Another resident asked about what might happen in an emergency, since a lot of the first responders out there are volunteer fire departments. RES, talked about incidents being rare, but they did indicate that they might be open to an agreement with the community to donate resources to local volunteer fire departments. Another question was about eminent domain. They indicated that all of their easement agreements are with private landowners and that they do not plan to ask the county government for any sort of eminent domain or to go against the wishes of any landowner, because there is both turbines involved and many miles of transmission lines if this project were to come to pass. And as part of that discussion, I also learned that part of this project may be in Benton County due to the logistics of where to put the transmission lines and the substations. So the Benton County Quorum Court may be involved in this as well. That's about what I learned. Thank you.
So let me ask you, you said, just refresh my memory, it was 2029 is when they projected?
Yes. Yeah, and that's they put up a website recently, and that's up on their website, potential 2029.
Okay. Thank you.
Sure.
Very, very informative. I have Justice Rivera Lopez.
This is a very interesting topic to me, both personally and professionally. I do care quite a bit, but I would like to frame this for everyone who is watching, for everyone who is sitting here, about what we are talking about. We are talking about the production of energy. Currently, Northwest Arkansas as a whole, about 8% of our total energy is renewable energy. And that is almost entirely from the Beaver Dam. The Beaver Water District has petitioned to the, I believe it's the Association of Military Engineers, who oversees all of the dams in the United States. that they would like to petition for more of that water to be designated towards consumption, towards our water needs. The reality of that is that that would mean that more of our power generation is going to be non-renewable. And if it is non-renewable, it is not a sustainable long-term solution. That's the reality. If we want to talk about ecology, we want to talk about the environment, then let's talk about the environment. If we continue on the course that we are currently on, Washington County will have a similar, so this is research done by First Street. They're an organization whose primary initiative is regarding wind and air quality for human beings. By 2040, Washington County will have a similar air quality rating to what is currently ongoing in Los Angeles. Are you all familiar with Los Angeles, with smog, with fire? We understand that these situations are real and they are happening. It is not a matter of debate. We could go one further. Are we aware that Arkansas experiences the 12th most rainfall of any state in the country? You all live here, you all experience very humid summers. Are we familiar that as wet bulbs? So wet bulbing is a very interesting phenomenon. It has to do with how humans cool ourselves. We have a very interesting evolution to cool ourselves, and that is the ability to sweat. The problem with humidity is when it is very humid, it is very hard for sweat to evaporate. That's how we cool. Sweat evaporates off of us, it cools our body. It's how we thermoregulate. As temperatures increase and we are in a situation where there is large humidity, we stand the risk of having very, lethal sorts of summers, lethal sorts of heat waves. Heat waves are a reality of the world that we live in. They are a reality of the area that we live in. If we are not forward thinking about how we are producing energy, then we are going to exacerbate things that are already happening. I'm not saying that we should build every wind farm. Again, like Rio Stafford said, there are people who are taking approaches to how would we mitigate the environmental factors that are associated with wind farm production. But what does that mean for any other scale of energy production? There's already ecological disasters that are a product of the current way that we produce electricity. Coal and natural gas being the largest two forms of fuel that we produce. There is a coal burning plant in Taneytown. Again, I just don't believe that an environmental ecological reservation is justified. And again, I don't believe that the absence of a perfect action is a justification for taking no action. We are facing a climate catastrophe, not just here, but around the globe. And if we do not mitigate heat, if we do not find ways to take better approaches to thermoregulating human beings, again, what do we know of? What is the one that we are most familiar with? Air conditioning. Air conditioning is taxing on an energy grid. If we were to face blackouts like they face in Texas, what would that mean for a large portion of the elderly who admittedly do not have the same capacity to thermoregulate? I don't want people to die because we can't be forward thinking about the issues that we see. There are going to be sacrifices that we have to make about how we power, how we provide energy, but it is not a justification to do anything because we don't like them. Now, I'm not saying that I am a full proponent of wind energy as the only way, but there has to be a genuine conversation about how we use more renewable energy production in our area. Thank you, Chair.
Thank you, Justice Lopez. I will say that Texas is independent of the national grid. Yeah, so that's why they were in the trouble that they went in, and hopefully they've corrected it. So thank you. I have Justice Fleming.
Thank you, Chair. Well, we all know that wind energy is not going to, it's kind of like your solar panels. We got a set of solar panels out in Lincoln that covers about 12 acres that's got 3 batteries packs. It's big as semi trucks that, supposedly they self-extinguish. They may and they may not. They talked about Mr. Rio Stafford, which I've been to these meetings at Cincinnati, and they talked about a wind turbine catches on fire. It's kind of like these electric cars that run around Fayetteville all day long. We don't have a fire truck to put them out either. So we don't have a fire truck to put out a wind turbine either. And we talk a lot about the oil. Them turbines got about 128 gallon of oil in them. You know, 128 gallon of oil ain't going to destroy the world. Oil comes from the ground. Put it back in the ground. It ain't going to destroy it. It might kill the grass for a little bit. There's issues in everything we do. Either it's solar panels, either it's wind turbines. And yeah, when these wind turbines run out of daylight and they're done, it costs you about $1 million to take one down. And if a company goes bankrupt, yeah, the taxpayer is going to be liable for it. But the taxpayer is going to be liable for Nuclear One, which is down in Russellville, which is the most cleanest, effective energy they are. And it's been a good source of energy. It's been very dependable. But if that dude blew up tomorrow, this courthouse wouldn't be here. So it's very dangerous as well. So, you know, we can talk about energy all day long. And I think the wind turbines is a supplement. It's not a cure. The solar panels is a supplement. They're not a cure. The coal burners, they're nasty, but they're reliable. Nuclear One's very reliable. So, you know, we can toss this around all day long. And another thing's coming that everybody's, you know, we're fighting over a little bit of wind turbine. They could be a waste management trash dump put out there somewhere too. We don't want to, Washington County residents is going to fight the battle of a landfill in Washington County soon. It's coming, and it's coming like a big train, and everybody better be ready. Would you rather have 40 wind turbines to look at or a 200-acre landfill? I'm not saying it'll be there. It's going to be somewhere. It's coming, because Tawnytown, there's a gentleman here, comes, and he talks to us a lot, which it's out of our hands, it's out of our control, and it's in the air, and it's happening, so just be prepared. I'm not going to say I'm for the wind turbines. I'm not going to say I'm against them. I don't have enough knowledge to make a good vote either way right at this point. They're a long ways away from ever having a decision made right now. And I've talked to a lot of my constituents out there. I can name names for an hour and a half here. I've talked to them on the phone. I've got some for, I've got some against. I've got farmers that's for, and I've got farmers that are against. I've been working in Bearville for 9 months. I've been over in Carroll County riding around with farmers over there, and you don't want me to say what they got to say. Some really like it, and some you don't want to know what they say. So this thing is really, really early going on, and it's really, you know, we've got to have a lot more information. We've got to have a lot more talk. What we're doing is good. We need the information from the citizens. We need the information from Res. And the meetings I've been to so far, I haven't heard anything about federal government money, aid. And, you know, a lot of this stuff, the big solar panels we got in Lincoln, the school district got a big cut on taxes and stuff. And they talk about this wind turbine is going to, it's going to be about a $150 million deal for our schools to get their money, what I'm trying to say, what is it?
Rebate? No.
Yeah, the tax, you know, there's going to be money there for our schools in that area too. So I don't know. So, you know, I'm still up in the air and still rolling it around.
Okay.
Thank you.
I want to say thank you to everybody who participated in this discussion. Like I said, I can't say it was a town hall, but it was a county services meeting with an open discussion, and I hope we have some more of them. I would like to thank our JPs on the court who contributed to this discussion. Thank you, Justice Rio Stafford, for attending the meeting. I was working, I saw that, and there's no way I could have attended. So thank you for representing the court, and Justice Fleming, Justice Lopez. With that, we're moving on to item number 12. And this is Concerned Citizens of the Ozarks Wind Project presentation. If you would come to the mic, please. What?
This is my agenda item. I placed it on the agenda. I want to introduce it. I have that right. That's my point of order. So you need
Okay, excuse me. You asked if I could put this on my County Services Committee meeting, and I said yes. Now, if you would like to introduce it, you can just simply ask and not be snippy about it. Just ask, may I introduce it?
Yes, I would like to introduce it.
Okay.
Thank you.
We have Justice Coger who would like to introduce the concerned citizens for the Ozark project.
Thank you, Madam Chair, and thank you, gentlemen and ladies, for
I don't have control.
taking the time to listen to me. I'm a member of Concerned Citizens of the Ozarks. Our organization,
I don't have that.
and I'm just doing this without notes, our organization got formed primarily in response to the Nimbus Wind Farm being built in Carroll County. And because one of the problems that arose as a result of the construction, of the planning and the construction of that wind farm was a lack of communication, lack of information to the community. The wind company, Scout Clean Energy, approached landowners and got them to sign easement lease agreements in order to construct the 15,000 acres they felt that they needed in order to build the wind farm on the highest ridges in East Carroll County. And each of those landowners signed, as part of the lease agreement, there's a non-disclosure provision, which prevented them from discussing with other members of the community the plan for the wind farm. As a result, the planned construction was a shock to a large segment of the community. And a lack of knowledge drove a lot of hard feelings. The impetus for Act 945, and I want to stay within the chair's parameters. That was the primary purpose of my presentation, was to discuss Act 945, how it came into being, what it contains, what it doesn't contain. And I'm going to stick with that, but I'm not going to get into legal disputes.
Thank you.
Arkansas was one of the few states in the country that did not have any regulation of wind farms. And the occurrences there in Carroll County and the concern by other citizens in other counties that there was a lack of regulation in the state of Arkansas regarding the construction of that wind farm gave rise to what was passed by the General Assembly back in March, Act 945, which is the Arkansas Wind Energy Development Act. That act was necessary because the wind energy industry has changed. 25 years ago, wind companies came to Arkansas with the idea of building wind farms, but the technology did not exist to take advantage of the low wind speeds that exist in Arkansas. If you were to take a wind map of Arkansas, you'll see that the state is pretty much divided diagonally by a line. There's very little wind to the southeast in the Delta area, and there's a lot more wind here in the Ozarks, especially on the ridges. Now, there's enough wind in the Delta now, and there's certainly enough wind here in the Ozarks, because the technology of wind farms and industrial wind turbines has changed, in large part because they're huge. 25 years ago, the typical wind turbine was 250, 350 feet tall. Now they're reaching close to 700 feet tall. We're talking about land-based wind turbines. They're huge. They are industrial machines. They're not pretty little Dutch windmills. They are industrial machines, and a wind farm, a industry favorite phrase, is composed of, 25 to 50 or more of these giant industrial machines, plus ancillary buildings, underground wiring, transmission lines running the power from the grid to the grid from the farm. So it would appear to me, based on my review of your proposed ordinance, which I believe is probably an adoption of an existing ordinance, to fall within your definition of a large-scale development requiring a conditional use permit. Those that helped write Act 945 took a great deal of time to research how other communities have and other jurisdictions have regulated wind farms, how that regulation has changed over the years because of a change in the industry. And we also took the experience that we had in Carroll County about a lack of disclosure, a lack of information, and we put together Act 945. Now, Act 945, I've heard comments from RES that Act 945 is extreme. For example, they say that the setback requirement is 3 times the industry standard. The setback requirement, which is the distance from the base of the tower to the nearest property line under Act 945, is 3.5 times the height of the tower, but not less than 2,500 feet. Or in the case of a church, a nursing home, a school, a public park, public highway, an airport, 1 mile. Well, that is extreme compared to the industry standard, but the industry standard was developed 25 and 30 years ago when wind turbines were only 250, 300 feet tall. The industry standard is 1.1 times the height of the tower, with the idea that if the tower simply fell over, then the adjoining property would not be affected. Well, we're talking about towers that are 700 feet high, weigh, conservatively speaking, 240 tons. The nacelle, which is where the generator is about the size of an extended school bus. They collapse. They get struck by lightning. The blades are made out of fiberglass and wood, composite. They wear out over time. They have to be replaced. But while they are wearing out, they shred. They shred fiberglass. If they collapse completely, there's an instance in New York, for example, where the blades on a wind turbine completely shredded landed in an adjoining property owner's hayfield. There's fiberglass throughout that entire hayfield. They're still litigating over who's responsible for paying for that. That farmer had to buy hay to feed his cattle because he couldn't use his own. What Act 945 does is it emphasizes the importance of having full disclosure by the wind company to the community. It brings the construction and operation of the wind farm under the Arkansas Public Service Commission. A wind company must get a permit. As part of that application process, it must provide to the community copies of its application. It has to provide public notice in a variety of ways, providing copy to the county clerk, providing copies to the public libraries, providing written notice to people that live within a certain diameter of the proposed wind farm. The wind company must conduct public hearings in the community within a certain time frame. They must respond to questions from the members of the community substantively, such as what Rez did apparently at the Cincinnati Fire Hall. That was a problem that we had in Carroll County. Scout carefully orchestrated these public forums. For example, if you wanted to talk about the birds, you had to go over to this booth. If you wanted to talk about the karst terrain and the potential damage to the hydrology, you had to go over to this booth. And so they divided the people up so they wouldn't hear. You didn't have an open forum like this. People didn't get to hear what was going on unless they went from booth to booth to booth. And the purpose of Act 945 is to make sure that there's a lot of community involvement. Importantly, very importantly, Act 945 makes it clear that local governments can impose their own rules regarding the construction of wind farms, provided they are not less restrictive than what is in the Act. For example, Washington County could not say, we don't like a 2,500-foot setback, we want it to be 2,000 feet. It recognized that it's the quorum court's responsibility to always look out for the health, welfare, and care and the property rights of all of its citizens, not just those that sign the lease agreements, but those that do not sign the lease agreements, but who still have to live with the consequences of the wind farm. Now, I know you don't want to talk about moratoriums.
Correct.
But I do want to point out to you that several counties here in the Ozarks have adopted moratoriums. And the reasons why they adopted those moratoriums is because of the legislature's recognition of the importance that the local governing body play a role in the process. For example,
Period. Let's just go ahead and move on. Okay.
Things that are not covered by Act 945 that a county might want to consider.
That sounds good.
Point of order. The chair is not supposed to interrupt a public speaker. I would like a ruling that the chair is violating the rules when she interrupts a public speaker.
Point taken. Continue, please, sir.
So you have to rule, or I can read it I can read that point 3 more times and call for a vote myself. I'm about to do that.
You're not recognized. Thank you. Please continue, sir.
Point of order.
Your order was taken. The chair vetoes and doesn't agree with that. And so,
I appeal your ruling.
okay, the ruling has appealed that I'm not allowed to engage the speaker at any time. All in favor, say aye. All opposed, say no. No. Continue, please, sir.
Thank you. Well, for example, I understand that Washington County is becoming a premier destination for trail bike riding. And it might be something that this county might want to consider providing a buffer around its current and future proposed trail bike riding, which is a huge source of tourism in northwest Arkansas, to protect those routes from the visual disturbances, I'll call it, of a wind farm. The county might want to impose special fire protection methods. I met with the fire marshal in Carroll County, and I asked him, what are you going to do when one of these turbines catches on fire? He said, George, I'm going to drive my pickup truck up there and I'm going to watch it burn. During the course of deforesting the ridges, a fire occurred at the Scout project, the Nimbus Wind project. It took 5 different jurisdictions to put that fire out. because this was on top of a wooded ridge. The fire got down into the forest, and it took 5 different jurisdictions to put that fire out. So a county might want to consider requiring the wind company to provide certain protective measures, such as requiring each turbine to have a fire suppression system, providing a source of water for each turbine should it catch on fire. Now, these things are expensive, but so is the potential damage and loss that could occur from a fire that breaks out as a result of these collapsing turbines. They collapse. They do catch on fire. They're like oil cans on lightning rods. So there are many unique things that might exist in Washington County that need to be addressed by Washington County. That's why the General Assembly specifically stated in Act 945, local jurisdictions can adopt their own rules and regulations concerning the wind farm. Now, you can do that as part of, if RES or some other wind company comes along and seeks a conditional use permit, you can impose these things that you consider unique to Washington County, or whatever you think is a good idea, whether it's Washington County unique or you think just a good idea, as part of that conditional use permit. But at that point, you're going to be in the process of going through the timeline and the considerations of that permit at that time. I urge you to consider the things that you might want to consider and impose and place reasonable restrictions on a wind farm before that permit application comes in. Whether you, I'm not going to use the word moratorium.
Thank you.
Now, I know that the Arkansas Association of Counties has suggested that a county that does impose a moratorium could fall afoul of Act 945. And I heartily disagree with that. Matt Bishop, an attorney here in town whom I believe you all may know, heartily disagrees with that. The Carroll County attorney heartily disagrees with that. Act 945 specifically gives to local governments the power to regulate wind farms. Now, I can go through Act 945. I'm sure you all can read and understand it as thoroughly as anyone, but I'm happy to answer any questions you might have, because I know it is almost 8:30 and you've had a long meeting, and I don't want to extend it unnecessarily.
I want to thank you for the information that you gave us, and very well
Thank you.
presented. Are there any questions? I have Justice Dennis.
Thank you, Madam Chair. Very good presentation. I'm interested in knowing a lot more about it. Is there a website?
Yes.
Yes.
Yes. We
Very good at
actually put
website.
together a link tree, which has, and we can provide that information to you by email. If you go to the concerns, this lady right here can
Excuse me, can you come to the microphone so that way it's being recorded, and pull it down so everybody can hear you?
Hi, my name is
Thank you.
Angela Ushry. I'm with Concerned Citizens of the Ozarks, and we do have a link tree. We have a QR code. It goes to an entire copy of Act 945 plus articles, more information than you'll ever want, but it's a good source for just, and we also have an interview with Kansas State Senator Mike Thompson. They're now living with the results of, I think they have almost 10,000 turbines in Kansas. They started with a farm not much larger than what we have in Carroll County.
And the website is Concerned Citizens of the Ozarks.
It is CC of the Ozarks.
Yes.
I've got business cards I can hand out. I
Yes.
have tried to email all of you, just so you know, half of them bounce back. So the ones that got it, congratulations, but we did try to send this, I think we tried to send it twice now, but we can try again.
But it's easy to get to your website. I did.
Well, I would say that if I'd like to know about it, I know a lot of other people that would like to know about it too. So you're not only telling me, but you're telling
Right,
Washington County.
of course. And I have the QR code with us. I can airdrop it to anybody because the link tree was just finished a couple of days ago. The information's been updated this past week.
Thank you very much.
Thank you. We appreciate your time.
Justice Lemming.
Thank you, Chair. I did get yours, and I did read through it and look at it a lot. The senator he's really good to listen to, the one in Kansas.
I'm sorry, say that
The
again?
senator that's in Kansas?
Yes.
He's got a lot of information. He lays it out good. And I've got his video on my phone right now. You can pull it up and look at it.
One of the things that I thought was particularly informative was his take on what counties would anticipate in the way of property taxes from the construction of wind farms.
Mm-hmm.
And if you'll like to take a look at the state of Oklahoma, an example, a lot of the Oklahoma school systems actually budgeted that incoming money and spent it. And then when they tried to collect it, there were 19 different lawsuits by 21 different wind companies trying to get out of that tax liability, and ended up with a lot of those school districts were in the red as a result of having spent money that they thought they were going to get, but ended up not getting. And that's another thing that the quorum court might want to consider in how they're going to go about assessing and collecting taxes on a wind farm, considering whether or not to enter into a payment in lieu of tax agreement, pilot agreement with the wind company. There's a lot of things to consider financially, as well as its impact on the community and on the environment.
There's a lot to learn about all this.
Yes.
I mean, there's a lot to learn. And like you just talked about the budgeting for a school. If a farmer gets 2 turbines and the wind company don't want to pay him that much, they can just turn one of them off, put the brakes on it, and the other one just gets paid for one.
Well, further to that, as an example, one of the landowners in Carroll County was promised during the negotiation that they would get 3 wind turbines on their property. Now, the more turbines, if you have a turbine on your property, you get more money than if you don't have a turbine on your property. But by signing the lease agreement, you've committed your property to the farm.
For 20
years. And so
years.
the wind company can use it
However.
however they need it in order to, whether they just want to run an access road across your property or not. Well, this particular landowner who was promised 3 turbines, guess how many they got?
0. Well, and when you do that, I mean, I've heard numbers as high as 23 to 25,000 per turbine. That sounds pretty good to a farmer, but if you don't get any, that sounds terrible.
Well, and that's another aspect of Act 945. Act 945 requires a great deal of transparency regarding how the landowner is to get their money, their right to access the books and records of the wind company on a regular basis at the wind company's cost.
Thank you.
Thank you, sir. With that, we're going to end the discussion and move on to a citizen comment time.
Thank you very much.
You're welcome. Thank you for the information that you gave us. You can come forward, please. State your name.
My name's Lisa Minotti. Thank you for giving me a minute here. I wasn't really going to speak, but I'm going to say there's a couple things that have really been weighing on me about this project, and to George's point on the transparency by this company, Res. When we found out about this project, I tossed my little invitation on the counter and didn't think twice about it. And closer to the meeting came, we were like, holy crap, what is this stupid thing? We went to the meetings, blah, blah, blah. Anyway, I started talking to more people in town and realizing that hardly anybody knew about this project. I mean, literally every single person I speak to in the city of Lincoln, up until very recently, had any clue about this project. That bothers me. And the conclusion that I have come to is I really believe that Res only sent invitations out to a certain number of people, and those people owned 50 or more acres. I believe that that is true. I also believe that all the JPs have received a copy of the contract from Res that we got from, well, they were sent to you. Again, all this kickback on emails, I don't know what is happening with all of that. But anyway, I can get that to you, excuse me. And in those contracts, you will see that non-disclosure agreements are a part of that. I do not see how that is transparent. I would like somebody to explain that to me. What are they hiding? What are they afraid of? I mean, for neighbors to not be able to talk to neighbors or your community, that to me says a lot. I don't like it. And I just urge our community and I urge the JPs to really keep that at the forefront. This is a multi-million-dollar company. We're nobodies in the city of Lincoln, Arkansas. I don't know how else to say it. Big dollars is, dollar signs are flashing in people's eyes. This is going to be a fight, and I hope we can win it. And I just hope that y'all keep that in your mind when you're considering this. Thank you.
Thank you. Citizen comments time.
Hello, everyone. My name is Beth Koger. I live at 3661 Embry Drive here in Fayetteville. Madam Chair, I'm just making sure you were listening.
Of course.
So I'm here tonight to speak about an issue that has been hanging in the wind for a long time. And I want to give you a little background because while everyone around this horseshoe already knows all the details, some people in the audience and some people watching online may not know. So, in 2023, I sued Washington County because they violated the Arkansas Freedom of Information Act.
Excuse me, is that relevant to the agenda?
Yeah, it doesn't have to be relevant to the agenda. It can be anything.
You can ask our county attorney. It's relevant to the agenda.
It doesn't.
Thank you.
Okay. Anyway, so I have two judgments against the county. Two courts of law awarded me judgments, the Arkansas Court of Appeals and the Washington County Circuit Court. They said, hey, Washington County violated the law. They owe Beth Koger money because she pursued a lawsuit and she won. Okay, so 47 days ago, this quorum court, most of the people sitting around this horseshoe, there may be one missing, passed an ordinance and appropriated money to pay my judgment 47 days ago. Does it really take 47 days for Washington County to process payment, especially a legal judgment? So I'm here tonight, and I'm not begging, and I'm not asking. I'm telling you that if my attorney has to take other legal action to collect this legal debt, I'm going to come back, and I'm going to ask that I be reimbursed for that fee. Last time, in my first judgment, I had to file a writ of execution. In case you don't know, a writ of execution is a document that's issued by the clerk, and it goes to the county sheriff. The sheriff has to pick up county property, attach it, and sell it at public auction to pay my judgment. Is that really where we're headed? Or I could do a writ of execution. I mean, a writ of garnishment and garnish a county bank account. I don't want to do that. I just want to be paid. Another alternative is finding the county in contempt of court. Again, whatever legal remedy there is, I'm going to leave that to my attorney, Mr. Steve Zago, because he's very capable, and he's stood beside me through all of this. So I'll leave that up to him. But I'm just telling you that I will come back here and I will ask for payment. Just because I'm not popular in the county or on this court, you still have to honor your debts, and you have debts to me, and I want to be paid.
Am I okay to proceed? Just wanted to double check.
You sure can.
Thank you. Sarah Moore. I'm the executive director of the Arkansas Justice Reform Coalition. And I've heard the county talk about many of the building projects that are happening. I've heard about the emergency management center that's being built. I've seen touted about using the old CSU building to be repurposed to the CRI initiative. And I've seen in the news and touted the project that started in 2019, the Patriot Park housing of 60 units. But what I don't hear put into the news cycle, and I don't hear updated by our county, is the fact that we're building a $19 million addition to the Washington County Detention Center. It's currently the biggest project that we have underway with taxpayer funds that started in December of 2022. We have a dedicated person paid by taxpayers that oversees these building projects, but yet even when we heard from county services today on the sheriff's report, there is never any mention of where that building project is, what the current budget allocation is, or if this is going to be delivered at a certain time. And so I wanted to get you a little bit up to speed. When we look at the EOC Center, it's very common for construction projects to run over, but that one's running over 6% the original budget, $500,000. This had $18.8 million that was allocated, and we've currently spent 18% of that a budget. And so I'm curious if the project is 18% complete at this time. We spent $795,000 to Height Jackson, about $500,000 to Nabholz, $575,000 to Grant Garrett Excavating, and $764,000 to Nabco Mechanical. And when you look at the way that some of the budget has come in on some of these, in particular, when I look at the red dot building systems, and I'll provide this to you on email, the detail, that was originally budgeted at $223,000, and that's now come in at $286,000, which is 28% over budget. I really hope that we'll get updates on an ongoing, regular basis to the public on what's happening and proceeding, especially because if you think of the quarter-cent sales tax that we currently have that's being collected, it's woefully underfunded at $17.8 million coming in from the quarter-cent when we're running an operations jail budget of around $25 million. That's $8 million over what we're collecting that we're dipping into reserves. These additional 88 beds and the debt for this capital improvement that we're going to see is going to continue to have the potential to dip into our reserves. And so as our fiscal stewards, I would ask that you would ask for public updates ongoing. Thank you.
Public comment. We have 3 more minutes.
I'll be real quick. I just wanted to appreciate Chair Ecke for allowing us the opportunity to speak, and Justice Koger for inviting the concerned citizens of the Ozark. I wish we could just keep George. He's a wealth of knowledge, and he presents it so well. I did want to comment, one thing I did leave out earlier is people really understanding the scope of a project like this. I do a Saturday run to go get milk at a local farm and go stop by the Cincinnati Fire Station and chat with the gentleman there. And when I mentioned to them this last Saturday, the height of the towers, they were like, oh my gosh, we would see them from here. And I think people just, they don't understand the scope of it. So I think the more we can educate people and get them more engaged. And there are people here tonight from the Lincoln area who I think are still a little shy to speak, but just I really appreciate them coming as well. So thank you all.
Thank you. We got 2 minutes left. Go ahead, Mary.
Hi.
3-6. I have a motion to increase my income by, thank you, it's been increased. Go ahead.
Okay. Well, hello again. My name is Mary McKinney. I live
I'm sorry, we didn't vote.
Oh, excuse me.
All in favor say aye. Aye. All opposed? Please continue.
Okay. My name is Mary McKinney. I live at 19980 Lakeview Road. Let me just say some positives here. The zoning ordinance and allowing that for the appeal, I appreciate you mentioning that. We kind of gotten caught in the gap with that in my situation with Eagle Crest. So I'm really glad to see that that has been closed, and I appreciate that. In addition, the stiffer penalties are good, going from the $250 a day to the $1,000. But I would tell you that that's just as good as what's on the paper if you can't enforce those penalties. I did some quick math from my background. We did a lot of math in not-for-profits. If those penalties are enforced, you could pay for a code enforcement officer. And likely, you could pay for a fire marshal, which this county desperately needs. So there is a means to fund those positions if there is enforcement when, in my situation, when a CUP is not being enforced. So thank you for making those changes or proposing those changes. I know they're not adopted yet. I did the quick math. Eagle Crest operated 6 months without a conditional use permit. That's $45,000 on the $250 a day. That would have funded one of those positions. If you do it by the 1,000, well, then you're going to fund many positions. So thank you for that. My next thing I want to speak to is, well, let me back up to enforcement. We made attempts to have it enforced. County Attorney Lester said that with CUPs, his office is who would enforce it. No return emails, no return phone calls. So we were unsuccessful in any attempts to get that enforced. Now, it's true. As County Attorney Lester has told you, there's a federal lawsuit filed. If you don't repeal the ordinance denying them the CUP, according to Brian Lester, you won't prevail in the federal court.
Mary, you have 30 seconds.
Okay. I guess to access that information, you can't access it on the court data that he mentioned. You have to have access to the federal court. I will tell you that Eagle Crest right now at $25,000 a month per a census of 15, that's just shy of $500,000 a month. They are a commercial business. They are not a group home. They are an inpatient drug alcohol rehabilitation center. They are clearly a commercial business. They are not a single family at all.
Mary,
and I would like to ask you, like I've said before, ask more questions, dig a little deeper. There's more to this story than you are being told.
Thank you.
Thank you.
Public comment time.
Hello,
Hi.
my name is Carrie Pierce. I live on 13115 Rothrock
Can
Road.
you get closer to the mic so we can hear you? I want it to be recorded, so thank
Yes,
you.
Carrie Pierce. My address is 13115 Rothrock Road. I have never attended one of these meetings regarding the windmill project. I just heard about it yesterday. My house will be directly involved. I'm on the east side of the ridge. How is nobody, this is not our whole county that's going to be affected. How are we not hearing about it? Because we don't have 50 acres or more? That's not right. We're all going to be affected. I think that's really unfair. We get flyers all the time. I get tax bills. They find my house. Why are we not being informed? I think everybody that's going to be living in that bubble that's going to have direct impact should be told. Because there will be a whole lot more people here with a whole lot more opinions about it, but we don't know. And I think that's unfortunate. Thank you.
Sherry Main, Riches Road, Fayetteville. I got to thinking after I made my comments earlier, the amendments to the revised zoning and planning ordinance are probably not going to be passed by August 5th, which is when you need to, the county needs to be in compliance with Act 519 before that date. So I had just respectfully submitting this as an idea of doing an ordinance, something like what Attorney Lester did to this one, but amending, going back and amending the original administration of the judge appointing the planning board, which he's required to do, and change some of the wording in that original. It's been that way for 30 years. I mean, the planning board has not changed the wording. and they've been making $75 for 25 years per meeting. So why not go back, do an ordinance, emergency ordinance, because we have to have it passed by August the 5th to be in compliance. So do an emergency ordinance, add an amendment to include 10 people on the planning board. The judge can appoint 3 more from the unincorporated area. That will give you 6 out of 10. You'll have the majority in the unincorporated areas. And then you can change the wording in that also, while you're amending to Act 519, it can be added to the amended like it is in this as far as the wording and to be in compliance. It can also add in there, while you're amending, is to increase their pay to $250 or whatever you may seem that is relevant. I think $250 is fair and equitable. You may think more, I don't know, but that's just a suggestion. And that may actually give you more interest from the public for people giving applications to the judge to be on the planning board. It's basically a volunteer position. I did my application, it's $75. I didn't do it for the $75. I did it because I want to give back to my county. I think I am knowledgeable, and I think I have enough to bring to the table to sit at this horseshoe on the planning board. For some reason, I can't seem to get there, but and that may be a reason that the judge has that he hasn't shared with me. But I just think we need to address this in a way that's fashionable, speedy, and an emergency to do it before August 5th, so we don't have to be out of compliance. And then we can continue to work on the Planning and Zoning Board on the amendments, because now we have a wind farm, we have agritourism, we have a lot of stuff
Your
going
time is
on
now
that we
up.
need to address in that new ordinance. Thank you.
Thank you very much. With that, this meeting is now